So hello everyone and welcome to Career Launcher. So in today's class, we are going to discuss a very important topic. Actually, that was in the news in the last 1 or 2 days regarding the freedom of speech and expression in India and the regulation around it. So whether the freedom of speech is complete, absolute, or there are reasonable restrictions. If there are restrictions, then what are those restrictions? So we'll discuss it from the constitutional point of view. Okay, we will not be going in that detail about what are the controversies and all, because I hope you are aware of those controversies, and we are not supposed to go in that detail. But we will discuss the constitutional aspects, the legal aspects of that. That what are the boundaries set by the constitution, and what are the laws associated with that. So if I'm audible and visible, please write yes in the comments so that we can start our session. Am I audible, visible? Is everything fine? If yes, then please write yes. Okay, so let us begin with today's class. And I hope you are aware that the central government has actually wrote to YouTube to remove those videos which were still there. So after the controversy happened, a very famous podcaster and YouTuber had said something on on a comedy show, and after that, the things were there and all. Mr. Kanchan Gupta is an officer in the Information Broadcasting Ministry, and he has posted also that it should be removed and all. So we are not going in that because I'm not going on that research that whatever he has spoken, what the word is spoken and all. See, we have to understand one thing: if there is something vulgar or if there is something abusive, we are not supposed to repeat that, because we see a lot of people criticizing it by repeating the exact statement, which does not make sense. Because if something is abusive or vulgar, we should avoid repeating that even. Okay, so that is not what we are going to do. So we are going to learn about the laws in India regarding it. Okay, that if there is freedom of speech, what are the limits and all, and is there any judgment related with that? Is there any previous year question asked on this topic? So that is what I am going to discuss. Okay, so let us begin with the first question of the day. Which article of the Indian Constitution gives us the right to free speech in India? Now I'll discuss in detail that is free speech का क्या मतलब है, because just writing free speech does not mean that whatever you want you can speak, but there are limitations which we are going to discuss. So please answer this question, and this is a very easy question of the today's class. Article 14, Article 19, Article 24, Article 29. What is the right answer? So I expect everyone to answer it because this is a star mark question. ये बिल्कुल पूछे जा सकते हैं कहीं भी एग्जाम में. And the right answer is yes, option B. Yes, Priyanshi Goel, you're right. Article 19 of the Indian Constitution, rather I would say Article 19(1)(a). This is the most perfect answer of the Indian Constitution, talks about right to freedom of speech and expression. Because Article 19 में और भी बहुत कुछ है, ठीक है? So Article 19 contains other things also, but this is the most important thing. Article 19(1)(a). ठीक है? इसको देखो, 1 को ऐसे clause लिखते हैं, this is called as clause, और A को लिखते हैं sub clause, ठीक है? So like this it is written. Article 19(1)(a). ठीक है? So B is the right answer. Yes, Vidita and Hari, you are also right. Article 19 is the right answer. So yes, here is the article. When you read it, protection of certain rights regarding freedom of speech. So the first Article 19(1) says all citizens shall have the right to freedom of speech and expression. तो अगर आप इतना पढ़ोगे तो आपको लगेगा yes, मेरी कोई भी आजादी, I can speak whatever I want. But this is actually half knowledge. Why? Because you have read only one sentence and you have not read the entire Article 19. Okay. So first thing is we are having freedom of speech and expression. So then the second Article 19(1)(b) talks about right to assemble peaceably without arms. Means right to protest without, जैसे आप साइड में रोड साइड में प्रोटेस्ट कर सकते हो या जो भी, without arms you can protest against any decision of the government, etc. and all. Right to form association or union or cooperative societies, like people form associations and different trade unions are formed, cooperative societies are formed and all. Then right to move freely throughout the territory of India. Okay. Then Article what is this? Can anyone tell me? I'll be very happy. That what was this? And when it was removed. Okay. Therefore, ideally we will be discussing this, but I will try in this class to explain all the clauses, because I know that rest of the things may be confusion hota hai, and that is why I have decided to discuss all the entire Article 19, because I think it's important. What is Article 19(1)(f)? It was actually right to property. It was mentioned here also. ठीक है, which was removed from here by which amendment? 44th amendment. Yes, Ramjas and Ashnur Kaur both are right. 44th constitutional amendment 1978 taken from here to article 300 capital A. Now it is a constitutional right. Yes, Ashnur Kaur, Ramjas, you are right. Great, great, very good. Then right to reside and settle in any part of India. आप कहाँ भी जा सकते हो. Means आपको ये नहीं है right to move freely throughout the territory of India. Like for example, if you want to go from UP to Bihar, do you need any visa or a passport? No. You want to go from Tamil Nadu to Mizoram or something like that, you do not need any as such. है ना. Right to reside and settle in any part of India. You can go, है ना. If you are, let's say you are living in Bihar and you can go and settle in Tamil Nadu or vice versa. ठीक है. Or you are, let's say you are living in Haryana, you can go and settle in Maharashtra or vice versa. Right to practice any profession or carry or occupation, trade or business. So आपका right है कि आप जो है कोई भी business practice कर सकते हो. ठीक है. So these are the basic thing we have discussed. Now, one more thing, since we are talking about Article 19, the right to freedom of speech and expression. So this same article, you won't believe, even in Universal Declaration of Human Rights, Article 19 talks about this. This is surprising because generally it does not clash. That the articles in the Indian Constitution and the articles of Universal Declaration of Human Rights generally do not clash, but here it is. The surprising element is that even in Universal Declaration of Human Rights, Article 19 also talks about freedom of opinion and expression, which is similar to that, है ना? अच्छा, जो प्रेस की आजादी बोलते हैं ना कि press freedom or the journalistic freedom comes from here only, है ना? So that is what, or the journalistic freedom we say. It comes from there only. Now, so why I'm saying Universal Declaration of Human Rights? Because the CLAT has already asked question. The entire passage was asked in 2021, and ALET had asked question about Human Rights Day 22 या 23 में तरफ पूछा था. So if you have not watched this video, please go and watch it because this is important. Just go on YouTube and search UDHR Career Launcher. You will get this video. Please watch it. This is very, very important because they can ask question from here. NHRC National Human Rights Commission के बारे में मैंने डिस्कशन किया था इस वीडियो में. So that is what we are talking about, freedom of speech and expression. Now let us talk about the next question, and I hope you all can answer it. Please read the question carefully and then answer me. In India, the freedom of speech and expression is absolute, qualified, not permitted at all, none of the above. What is the right answer? I'm waiting for the response. Yes, qualified. Qualified मतलब क्या होता है? उसमें कुछ restrictions है. So freedom of speech is not absolute in India. It has some reasonable restrictions, right? What we call it as reasonable restrictions. जो मन चाहे नहीं बोल सकते हैं. You have to understand. ठीक है? Okay, so B is the right answer. Yes, Priyanshi Goyal, Vidita, Ramjas, you are right. It is. It has some reasonable restrictions. So we have qualified freedom of speech and expression. Now, when I'm saying that in India, there are reasonable restrictions on freedom of speech and expression. So this reasonable restriction is mentioned where? Article 26, Article 19, Article 144, Article 191. तो हमने तो Article 19 में पढ़ा कि freedom of speech expression होता है, लेकिन उसमें reasonable restriction भी है. ये कहाँ लिखा हुआ है? Where do I find that yes, there is freedom of speech and expression, but at the same time there is reasonable restriction? Means it does not mean. Yes, very good. Article 19 clause 2, Ramjas, very good. So basically, to be perfect, to be exact, I would say Article 19 clause 2 talks about reasonable restrictions on freedom of speech and expression that I'm going to discuss today. Yes, Ramjas, Vidita, you are right. B is the right answer to this question. Okay, like for example, when this controversy happened, the Chief Minister of Maharashtra, Honorable Chief Minister, Mr. Devendra Fadnavis said, everyone has freedom of speech, but our freedom ends when we encroach upon freedom of others. ठीक है? मतलब ये कि कुछ boundary है ना? The freedom of speech is there, but we have to be within that boundary. We cannot cross that boundary, है ना? So that is what we'll be talking about. मैं आपको Constitution Morality concept बताऊंगा, भीमराव अम्बेडकर क्या कहा हुआ, ठीक है? So then you will understand this in a very crystal clear way. ठीक है? So when we are saying Article 19(1)(a) talks about freedom of speech and expression. So when you read Article 19 clause 2, it is clearly mentioned. इसीलिए कहा जाता है पूरा पढ़िए आर्टिकल, है ना? सिर्फ इतना पढ़ के मत बोलिए कि I have freedom of speech, I have freedom of speech. Yes, you have, but what does it mean? You do not have a right to like use abusive words or obscene words or something like that. देखो इसमें clearly mentioned है कि there are reasonable restriction, ये word लिखा हुआ है on the freedom of speech and expression, है लेकिन nothing in the sub clause A of clause 1 यानी freedom of speech इसकी बात कर रहे हैं. Restrict the state and prevent the state from making any law in so far such law impose reasonable restriction like क्या है sovereignty and integrity of India, security of state. ठीक है ये हुआ. और पब्लिक ऑर्डर देखो जो जिसको 4 को मैंने हाईलाइट किया, थोड़ा थोड़ा डिफरेंस होता है बट मोर और लेस वी आर टॉकिंग अबाउट व्हाट. इस 4 में अगर आप गवर्नमेंट के खिलाफ इज लाइक हेल्दी डिसेंट इज फाइन, बट इफ यू आर ट्राइंग टू स्पीक एनीथिंग व्हिच इंपैक्ट द इंटीग्रिटी ऑफ इंडिया, व्हिच टॉक्स अबाउट ब्रेकिंग द इंडिया और लेट्स से इट इंपैक्ट द हार्मनी ऑफ इंडिया और सिक्योरिटी ऑफ स्टेट, देन योर फ्रीडम ऑफ स्पीच कैन बी curtailed. Okay, so there were laws we had seen है ना. So we'll discuss that also. Let's say for example we are having this law, like there was sedition, although sedition is no longer there, but there is a concept of section 152 of Bharatiya Nyaya Sanhita. It talks about the same thing, India's sovereign unity and integrity. So any criminal activities that threaten India's sovereignty, unity, and integrity of India, like armed rebellion, secession, and separatism, then of course there will be punishment. Okay, for life or up to 7 years, etc. and all. Okay, so इसका मतलब क्या है कि अगर आप इसके लिए if you are doing this, then of course there is a punishment. Then we are having public order के लिए. So there are provisions in the Bharatiya Nyaya Sanhita, like section 196, 123. So ये सब provisions are there. ठीक है, सबको रटना नहीं है, सारे sections नहीं रटना, but whatever the idea is that I am going to discuss. Now, so you have to understand. देखो ये concept समझना जरूरी है कि whenever we talk about freedom, so we have to talk in this perspective. देखो एक होता है एकदम highly liberal. So generally बहुत सारे वेस्टर्न नेशंस में फ्रीडम ऑफ स्पीच बहुत ज्यादा दिया हुआ है, टू मच. फॉर एग्जांपल इन सम कंट्रीज, आई थिंक इन अमेरिका आल्सो, लाइक आप यूएस के फ्लैग को जो है ना यू कैन वियर एनीवेयर, ठीक है, बट इंडिया में ऐसा आप नहीं कर सकते हो. देयर आर सम रूल्स एंड लॉज, यू हैव टू रिस्पेक्ट द फ्लैग. सो देयर फ्रीडम ऑफ स्पीच इज वेरी हाई इन सम वेस्टर्न कंट्रीज, सो मच so that I mean they sometimes allow an abusive vulgar language against the prophet or let's say against any god or something like that. This is one extreme. There is another extreme which is authoritarian, which does not allow even a single word to speak against the ruler, so otherwise you will be in jail. So this is authoritarianism. So what we in India follow is what we call it as middle path, or what we call it as madhyam marg. Have you heard this term before? This concept of madhyam marg is related with which religion? कोई बता सकता है? This is a specific term, although not given in the context of freedom of speech, but in general this term of madhyam marg was given by which famous religious scholar or philosopher? बता सकते हो madhyam marg का concept किसने दिया था? If you tell me, I would be very happy. So it is actually given by Gautam Buddha. So our constitution is believes in the concept of middle path. Yes, Buddhism. Yes, Ramdas, very good. It means there is freedom of speech. We allow freedom of speech, but with reasonable restrictions. Freedom of speech does not mean you should use abusive language. Freedom of speech does not mean you talk about speak like against sovereignty of India. It does not mean you use vulgar language. It does not mean you may start abusing the gods, the prophets of any religion. We need to respect each and every religion. Freedom of religion is there in India, but we have to respect each other, not make fun of each other. That is not allowed. ठीक है. So ये है middle path, यानी इंडिया जो है somewhere in the middle है, and that is the best thing about us, that we allow it, but at the same time we do not allow absolute freedom of speech, है ना. एक बीच में middle path है. Yes, Ramdas, Priyanshi, Goel, you're right, both are right. It's actually the concept, original concept of madhyam marg is given by Gautam Buddha जी. ठीक है. तो अब देखो ये हम लोगों ने डिस्कस कर लिया. देन वी हैव, अगर आप देखोगे कि और क्या क्या रीजनेबल रिस्ट्रिक्शंस है आर्टिकल 19 यानी फ्रीडम ऑफ स्पीच पर. तो ये हो गया फ्रेंडली रिलेशंस विद फॉरेन स्टेट्स, लाइक फॉर एग्जांपल इंडिया एंड रशिया इज हैविंग गुड स्टेट रिलेशंस. तो होता क्या, कभी कभी न्यूज वाले जो है रशिया यूक्रेन वॉर में मसाला वसाला लगाने के लिए something they were speaking which were actually considered कि they should not speak like that because it might impact our relations with Russia. ठीक है, तो आपको ऐसी बात भी नहीं बोल सकते. Then here comes जो आज का टॉपिक है वो है public order, decency and morality. This is what we are going to discuss because the topic we are discussing is actually lies here, the vulgar comedy or whatever you can say, because it goes against the idea of decency or morality. Okay, so indecent behavior in the public especially will not be considered as a part of freedom of speech. Rather, there can be obscenity laws, obscenity acts are there under which you can be booked also. let me show. Yes, like I was reading about it, this case, and Section 296 was imposed when this vulgar comedy news was very much in the news of Bharatiya Nyaya Sanhita, and it deals with obscene acts and songs in public places. It aims to maintain public decency and prevents disturbances. Why? Because Article 19, Clause 2 restricts freedom of speech in this context. Okay, तो उसमें लिखा हुआ भी give punishment up to 3 months and a fine up to 1,000 etc. So obscene songs, ballads, कोई भी obscene अश्लील गाना या words public में, obscene gesture देना public में. Similarly, Section 67 of Information Technology Act. This was also in the news regarding obscene material through electronic media. So of course here also imprisonment up to 3 years and fine up to 5 lakh rupees etc. can be there. Then इसको पढ़ लेना. So that is what the Information Technology Act, because whatever is now being transferred is through the social media and all. So of course, Information Technology Act is also invoked. Then Section 67, capital A of Information Technology Act, punishes the publication or transmission of explicit materials and all. Okay, so these are the provisions under which we had discussed that the Obscenity Act. These are the obscenity laws. Okay, so this decency or immorality. So is also, if someone crosses this line, then of course the freedom of speech can be curtailed. Then we have relation to contempt of court and defamation, incitement for offense. तो मैंने पढ़ लिया है ना, contempt of court and defamation. So contempt of court मतलब court का है ना, we are having this law called as Contempt of Court Act, है ना. So we are having civil contempt and criminal contempt. So it means if you willfully defy the judgment, then civil case can be initiated. And if you slander the judiciary, scandalizes the judiciary, the criminal contempt can be initiated. So this cannot be considered as freedom of speech. If you are openly making fun of the judiciary, this cannot be considered as freedom of speech. But healthy criticism is allowed. Healthy criticism of a judgment is allowed, but आप मजाक खिल्ली नहीं उड़ा सकते. मतलब you cannot you cannot defy the judgment, or you cannot scandalize the judiciary and all. Okay, yes. Then similarly, I've just discussed then incitement to an offense, just a hate speech and all. So these comes here. So hate speech cannot be considered as freedom of speech in India. So you cannot speak anything against one particular religion or caste or let's say, or etc. and all, against any particular tribe, something like that, which is offensive and all, because that is hate speech, and that is also a restriction on freedom of speech. That cannot be considered as freedom of speech in India. I hope it is clear. Then defamation, आप किसी को बदनाम नहीं कह सकते झूठा इल्जाम लगाकर. So that is what defamation is there, and I hope you are aware. So there was Section 499 and 500 in IPC, and later on when Bharatiya Nyaya Sanhita came, so these are like I would say Section 356 of BNS talks about defamation. ठीक है, so एक case भी गया था, Subramanian Swamy versus Union of India case in 2013, where they said that criminal defamation case should be quashed, but the Supreme Court said no, we will uphold this. So the defamation case can be both criminal as well as civil. Okay. So it is still there even today, because defamation case is there. Why? Because किसी का ना किसी के इज्जत respect को disrespect नहीं कर सकते हो fake news फैला करके or something like that. For example, there is an X person, he is a reputed person, and someone Y comes and in the media says in the public that X has done is a very bad person by putting false allegation. तो X जो है वो केस कर सकता है कि आप मेरे reputation के against बोल रहे हो. So freedom of speech does not mean you should spread a fake news against someone else, okay, or put false, unsolicited or false allegation against someone else. Okay, so that is why this is also a restriction in freedom of speech. So ये सारी जो है freedom of speech के restrictions हैं that I have just explained. I hope it is clear. Is there any confusion in this regard? If yes, then please ask me. ठीक है, एक जजमेंट ये पढ़ना कभी कहीं पूछा था कि राइट टू फ्रीडम ऑफ स्पीच रिलेटेड एक फेमस जजमेंट है. दिस इज मेंशन व्हेन यू रीड द हिंदू एडिटोरियल्स. आई एम श्योर यू मस्ट हैव कम अक्रॉस दिस. एस रंगराजन वर्सेस पी जगजीवन राम केस. इसमें जनरली सुप्रीम कोर्ट ने फेवर किया फ्रीडम ऑफ स्पीच को, बट दिस डज नॉट मीन दैट यस ऑफ कोर्स फ्रीडम ऑफ स्पीच शुड नॉट बी मिसयूज्ड आल्सो. Okay, now why we are discussing it, why we are so much talking about why this was very much being criticized that vulgar comedy should not be allowed. So we have to understand it, that why, because the crime against women starts, any crime starts, it goes on step by step. For example, if there are vulgar words uttered in comedy or somewhere else, and it comes again and again, and let's say the views on YouTube and everywhere increases, then what will happen? This will proliferate further. Okay, so people will start, the other people will also start using the same thing in the comedy, believing that okay, ये सब hit होता है कि अच्छा यही वाला चल रहा है आजकल बाजार में. This will make more hits, so people will start doing it, and it will be normalized. Means abusive language, which is derogatory to the woman, will be actually normalized in the society, so much so that people will start thinking that it is cool to make vulgar statements or vulgar remarks. Then, God forbid, the third steps happen, and the fourth steps happen, and the fifth step is the crime against woman is done. So always remember, whenever a crime is done, whether it's a crime against woman or a murder or any other crime, it is not done in the first step. So these are the previous steps which actually impacts a human brain, corrupts the human brain, corrupts the brain of a person since childhood, and then the person commits a crime. So that is why it is very important that we have to stop here only. This is what we call it as nip in the bud. कोई भी चीज बुरी हो रही हो तो जहां पर शुरू हो रही है एकदम वहीं पर रोकना है, आखिरी मोमेंट पे नहीं रोकना है. So this is what we have to understand. Because if just imagine a child is 8, 10 or 12 years old and he is watching actually a vulgar comedy, which is actually on OTT platform or anywhere else, and he sees that the other people are actually making fun of, and they are actually laughing on that. So what will happen? And the views are increasing and it becomes very popular, that comedy show. So the child will realize it is fine. इसी को कहते हैं normalize करना. The child will think that thinking about a particular woman in this way is fine. Then this is how the brain of a child gets corrupted. And then the third step, God forbid, and the fourth, and this thing happen. So that is why it is very important that we have to regulate. So it is why the freedom of speech is restricted. This you have to understand, because otherwise it will impact the youth, etc. and all. In the same way, like we say, हम लोगों ने last class में पढ़ा था, we had discussed about drugs. Okay, drugs is considered as a national security problem. Yes. Why? Someone can give a counter argument कि क्या drugs, if I want to take a drugs, why should government interfere? That is my job, that is my like or dislike. No, because if drugs becomes prominent in the youth, then the entire country is destroyed without any weapon. Let's say, for example, if there is a country X and there is a country Y. If X wants to destroy Y country without a weapon, then the X country can parcel out drugs to that country and destroy the entire youth. And that is enough to destroy any country. तो एक मुल्क को बर्बाद करने के लिए उसके यूथ के बर्बाद होना ही काफी होता है. So always remember, that is why we cannot say that this is a freedom of speech, that this is your freedom of choice, that yes, you can actually take any drugs and that is fine. No, the government comes and regulates. So the government has made NDPS law, Narcotics, Drugs and Psychotropic Substance Act, and we have Narcotics Control Bureau to control any drug supply, because this is actually a national security problem. Okay? So I hope you understand these things. The second thing why the crime happens in India is because I hope you are aware the criminal justice system is very slow, tardy and all. It takes almost sometimes 10 years, 15 years and all. That is also one thing that we should be knowing. एक और चीज जो मैं बताना चाहता हूं, that is about constitutional morality. ये आप लाइफ में बहुत बार पढ़ोगे. Constitutional morality. This is Ambedkar's concept. He has taken it from George Groot's article. ठीक है. और he talks about the concept of self-restraint. ये समझना जरूरी है. देखो थोड़ा सा मैं बताता हूं. When I say self-restraint, he says that everyone should have exercised self-restraint. ये बहुत important होता है. For example, the government should not cross the limit and enter into the domain of the common people. The judiciary should not also cross the limit. The executive, the legislature, all should be in there, should be within the limit. And at the same time, the citizen is also expected to be within the limit. The fundamental duties are there of the citizen. If the government has given freedom of speech or fundamental right to a citizen, the citizen should be mature enough to understand that I should be using my fundamental right in a restricted way. कि इंसान को जो सिटीजन है उसको खुद पता होना चाहिए कि हाँ मेरे पास फ्रीडम ऑफ स्पीच है, क्या मेरे पास कोई फंडामेंटल राइट है, लेकिन हम उसको बाउंड्री के अंदर में रह करके उसका इस्तेमाल करें, राइट. सो इट व्हेन इट टॉक्स अबाउट सेल्फ रिस्ट्रेंट, इट इज आल्सो इंप्लीमेंटेड टू द सिटीजन्स. ठीक है. सो दैट इज व्हाट द आइडिया ऑफ कॉन्स्टिट्यूशनल मोरालिटी दैट भीमराव अम्बेडकर टॉक्स अबाउट. कभी मौका मिलेगा तो आप पढ़िएगा इसको. ठीक है. Now let us talk about further discussion of Article 19, because I had promised that I will not only discuss about freedom of speech but other articles which is related with that. ठीक है. ये question है, this was asked in some exam किसी लॉ एंट्रेंस एग्जाम में ही पूछा था, आई थिंक MHCT में पूछा था या स्लैट में पूछा था, आई थिंक MHCT as far as I could remember. Who has the power to impose reasonable restrictions on freedom of speech? मैंने बताया आर्टिकल 19 क्लॉज 2 टॉक्स अबाउट फ्रीडम ऑफ स्पीच, बट किसके पास पावर है इंपोज करने का? सुप्रीम कोर्ट, पार्लियामेंट, प्रेसिडेंट, प्राइम मिनिस्टर. क्या होगा सर? तो लॉजिकली सोचिएगा, प्लीज थिंक लॉजिकली एंड देन आंसर मी. अच्छा, मैं एक चीज दिखाता हूं. यू रीड आर्टिकल 19. आर्टिकल 19(1) it talks about freedom of speech. तो रीजनेबल रेस्ट्रिक्शन कहां मेंशन है? आर्टिकल 19 क्लॉज 2 में. क्या लिखा है? नथिंग इन सब क्लॉज A1A, यानी इसमें क्या क्या एक्सेप्शंस है? shall affect the operation of any existing law or prevent the state from making any law to impose reasonable restriction. तो ये लॉ कौन बनाता है? Like I have just given examples of BNS. BNS की sections दिखाए कि नहीं कि morality, indecency, contempt of court law was made by parliament. Decency के लिए BNS के लिए laws made by the parliament. है ना? Defamation के लिए we have law. Incitement to offense के लिए we have laws. Parliament. So main law is made by the parliament. कुछ लोग हो सकता है ए भी बोल दे कि सर सुप्रीम कोर्ट के पास ही तो पावर होता है, लॉ डिक्लेयर्ड बाय सुप्रीम कोर्ट 141. यस फाइन, बट दैट इज नॉट द प्राइमरी जॉब ऑफ द सुप्रीम कोर्ट. जुडिशरी का काम लॉ बनाना जनरली नहीं होता है. इट इज एक्चुअली द नेम ऑफ द जॉब ऑफ द पार्लियामेंट. सो इफ द ऑप्शन सेज पार्लियामेंट, गो फॉर पार्लियामेंट. अभी हमने भारतीय न्याय संहिता बताया ना, BNS, ठीक है, पार्लियामेंट के द्वारा मेड लॉज है ना. So then we have Information Technology Act बताया, section 67, which was invoked in recent case. ये भी क्या पार्लियामेंट ने लॉ बनाया. So this was a question asked in a law entrance exam. That is why I'm saying, ठीक है. So who has the power to impose? So the answer is parliament mean. Okay. अब हम लोग और थोड़ा सा डिस्कस करते हैं आर्टिकल 19. So when we read a right to assemble peaceably without arms, but इसमें भी कुछ होता है. जैसे आपने पता होगा 144 लगा दिया था उस टाइम पर, CRPC होता था, section 144 of CRPC. Yes. So like आपने सुना होगा ना कि the SDM or the district magistrate has the power to impose, है ना, कि 4 या 4 से ज्यादा लोग, है ना, cannot assemble. Now instead of section because CRPC is gone, now we are having something like Bharatiya Nyaya BNSS. So section 166, 163 is there, which is similar to that. ठीक है, तो ये मैंने बताया, ये हो गया. Then we have right to move freely throughout the territory of India. ये भी absolute नहीं है कि आप कहीं भी जाओ घूम सकते हो. It is there, but with some restrictions. I hope you must have heard it, है ना. जैसे ये आपने सुना होगा, I'm sure you must have heard about it, especially in tribal areas. For example, we are having Forest Rights Act. We are having, ये सुना होगा आपने, I'm sure. जैसे inner line permit. Have you heard this? I'm sure you must have heard this. Inner line permit सुना होगा. That there are places in tribal areas or in the northeastern areas where the rest of the citizen of India cannot go without permission. Yes. तो ये है, तो मैंने बोला राइट टू मूव फ्रीली थ्रू आउट द टेरिटरी ऑफ इंडिया, बट रेस्ट्रिक्शंस आर देयर, रीजनेबल रेस्ट्रिक्शंस आर देयर. यस, इट इज देयर. ठीक है. राइट टू रिसाइड एंड सेटल इन एनी पार्ट ऑफ द टेरिटरी ऑफ इंडिया, इसमें भी रीजनेबल रेस्ट्रिक्शन. आप पढ़िएगा फॉरेस्ट राइट्स एक्ट, पंचायत एक्सटेंशन ऑफ शेड्यूल एरियाज एक्ट, ये सब पढ़िएगा. हाँ, मणिपुर ILP वाज इन द न्यूज़. सो यू विल गेट टू नो दैट यू कैनॉट, एवरीवन कैनॉट बाय लैंड एवरीवेयर. ठीक है. सम नॉर्थ ईस्टर्न एरियाज में फॉरेस्ट राइट्स एक्ट जहां पे होता है, जहां पे ट्राइबल एरियाज होता है, there are restrictions. You cannot go and buy land anywhere else. कुछ restrictions के साथ है ये. ठीक है. I hope you are aware. आपको थोड़ा तो idea होगा. I'm sure you must be aware of that. Then last वाला जो है, just right to practice any profession, carry on any occupation, trade or business. क्या इस पर restriction है? Of course है. मान लो for example, right to practice any profession. For example, if you want to open a clinic of a doctor, you must be an MBBS or an equivalent degree. अगर आपके पास MBBS या उसकी इक्विवेलेंट डिग्री नहीं है और अगर आप क्लिनिक खोल लोगे तो आप जान से मार दोगे लोगों को. यू माइट किल पीपल. व्हाट वी कॉल इट एज क्वैक, है ना, झोला छाप डॉक्टर इसको कहते हैं. बट दिस कैन नॉट बी अलाउड. नाउ ही कैन से कि मेरा प्रैक्टिस का प्रोफेशन, आई हैव अ राइट टू प्रैक्टिस एनी प्रोफेशन. नो, बट यू शुड गेट द डिग्री. आप बिना डिग्री के नहीं कर सकते हो. सिमिलरली इफ समवन डज नॉट हैव अ लॉ डिग्री, ही कैनॉट प्रैक्टिस एज एन एडवोकेट. बिना लॉ डिग्री के कुछ लोग करते हैं. So sometimes it happens, but this, like, the government can come. There are the rules, and Advocates Act is there. There are rules under which. So this does not mean that you can do anything whatever you want. Right to carry on any occupation, trade or business. आपको बोलेगा any occupation लिखा, so I can do drugs trade. But no, this is not allowed. This is under reasonable restriction. You cannot say कि right to any occupation का मतलब कि मैं drugs trade शुरू कर दूं. No, this is under reasonable restriction. The government can impose NDPS Act. Similarly, human trafficking is also not allowed. There are other articles, laws, sections also. So right to profession का मतलब ये नहीं होता है जो मन चाहे कर ले, ठीक है? So there is restrictions even. So basically you have to understand ये सारे चीज allowed है with reasonable restrictions. That is what I wanted to highlight. All these things are allowed with reasonable restrictions, because always remember there is nothing called as no absolute rights are there. ऐसा कुछ भी नहीं होता है कि कोई भी राइट एब्सोल्यूट होती है, हम जो मन चाहे करें. This is not the case. This does not happen with humans. Maybe it might happen with animals. Animals में होता है, humans में ऐसा नहीं होता है. Okay, so you have to understand it. So a civilized human being is always bounded by the laws, ethics, moralities, and the values. ठीक है, वो जो चाहे नहीं कर सकता है. Of course, there are regulations. ठीक है. Otherwise, if there are no regulations, then of course the instability will happen, the anarchy will happen in the country. So I hope it is clear. I have tried to explain Article 19 in a very simple and lucid way. और आप समझ गए होंगे. जैसे आपको right to form association, union, cooperatives, इसमें भी regulations होता है. So जब आपकी cooperative societies होते हैं, so there are laws under which it is governed. You cannot flout those norms. ठीक है. So ये सब चीजें I hope you will be able to understand it. Now अब देखिए, इसीलिए बताया जा रहा था कि देखो अब इंफॉर्मेशन टेक्नोलॉजी एक्ट वाज पास्ड इन 2000 और इससे रिलेटेड आईटी रूल्स बनाने की बात हो रही थी ना. 2021 में भी प्रपोजल वगैरह आया था. Why? Because OTT platform needs to be regulated. Because it has been seen recently, for the past many years, that OTT content is making content which violates Article 19 Clause 2. The reasonable restrictions on freedom of speech. They are actually promoting indecent content. They are promoting immorality. There are incidents. I hope you are aware of it. I don't want to take anyone's name, anything, but you have to understand. And that is why there is a need to, people say yes, there is a need to actually regulate those content and all. So NHRC member asked YouTube to take down obscene and vulgar videos and all. So when we are talking about NHRC, I had discussed about NHRC on this video. So आप just search करना UDHR career launcher, you will get this video. Okay. Now, so let me ask one question, and this question was asked in ALET twice, so that is why I'm asking it. But at that time, the answer was something else. Now the answer is something else. Who is the current chairman of National Human Rights Commission? So earlier, a former CGI can be the NHRC chairman, but now any former Supreme Court judge can become a NHRC chairperson. So who is the current chairman of National Human Rights Commission? Please tell me. Yes, Priyanshi Goel, you're right. The right answer is option C. Yes, Justice V. Rama Subramaniam. Yes, Priyanshi Goel and Kumari Bhavna, you both are right. C is the right answer. इससे पहले ये थे, the outgoing one earlier. So he had resigned in July last year. So now we are having Justice V. Subramaniam. And this is actually news of 24 December 2024. So this is a current affairs news for you also. ठीक है, तो ये भी आपको पता होना चाहिए. Yes. Yes, Priyanshi Goel, Justice Arun Mishra is his predecessor. तो ये जब एलेट पूछा था 2 बार, तो यही वाला पूछा था. उस टाइम पर ये न्यूज में थे. At that time he was the NHRC chairman, but now the answer is option C. Okay. Which of the following is correct about National Human Rights Commission? The constitutional body, statutory body, earlier a statutory, now constitutional body, none of the above. क्या सही बात है NHRC से related? What is the right answer? Let me see. Everyone, please press the like button and subscribe to our channel if you have not subscribed yet. क्या सही जवाब है? National Human Rights Commission is a no, not. It's B, statutory body. ये वाला जो होगा National Commission for Backward Class के लिए आंसर होगा. Earlier it was statutory body, later on became a constitutional body under Article 338 capital B. ठीक है. But NHRC is still a statutory body, so B is the right answer. Protection of Human Rights Act 1993 के अंदर बनाया गया. ठीक है. ओके, ये वाला जो मैंने बताया ना, ये वाला वीडियो ये देख लीजिएगा. ये प्लीज वॉच इट. ये पूछा हुआ एग्जाम में से बहुत सारे क्वेश्चंस. दैट इज व्हाई आई सजेस्ट प्लीज वॉच इट. ठीक है. ओके, द नेक्स्ट इज हु इज द चेयरपर्सन ऑफ नेशनल कमीशन फॉर वुमेन. और एक चीज और बताओ, नेशनल कमीशन फॉर वुमेन इज अ स्टैट्यूटरी बॉडी, कॉन्स्टिट्यूशनल बॉडी, कौन सा वाला बॉडी होगा बताइए. This was also in the news in this regarding this topic. National Commission for Women was also in the news. It had also taken suo motu cognizance and all. So there were complaints filed against these YouTubers. So that is why NCW was also in the news. People writing Rekha Sharma, but till now she was actually the answer, but now she has left the post, and now we are having option. Let me see. Anyone can answer. The right answer is option C, Vijay Kishore Rahatkar. So C is the right answer. Yes, Ashnoor Kaur, you're right. ये भी देखो, ये भी एक तरह करंट अफेयर्स ही हो जाएगा. अब 2 बार में बनाई गई last year. She will succeed Rekha Sharma. So Rekha Sharma was from since 2018 till 2024. अब change हो गई. So just remember, C is the right answer. Vijay Kishore Rahatkar. Yes, Kumari Bhavna and Ashnoor Kaur, you both are right. ठीक है. So it is also a statutory body made under National Commission for Women Act. So it's a statutory body made under the parliamentary law. ठीक है. Okay, so देखो NCW के बारे में we had discussed, है ना? It was in the news, and also NCW we have discussed. Okay, let's move on. Who is the Minister of Women, Child and Development? Since we are talking about these things, you should know about it. स्मृति है, I miss कर गया. ठीक है. What is the answer? Yes, now the answer is B. Yes, Priyanshi Goyal, you're right. Smriti Irani was earlier the Women Child Development Minister. Now the answer is Annapurna Devi, so B is the right answer. Okay. Yes, Priyanshi Goyal, you're right. Annapurna Devi. So B is the right answer. Okay. So this is all about today's class. So thank you everyone. Thanks for watching. Please subscribe to the channel, like the video, share. And I hope I have tried my best to explain each and everything associated with Article 19 and all. So thanks for watching. Have a nice day.